Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been geeking out with us for a while now, you know that not often do we get to talk about good news. No, actually, many times our videos are somewhere between getting punched in the mouth or kicked in the shins. But today, it's going to be a little different because I have some terrific news to announce. Now, it comes hot off the press here. I got the ruling right here, and this is the matter of Sullivan v. Ferguson. What is Sullivan v. Ferguson, you say? Well, if you recall, that is the case filed in the Western District of the state of Washington to overturn RCW 9.41.375, better known as our standard capacity magazine ban. So today, let's spend a few very important minutes and talk about a huge victory in the suit to overturn Washington's magazine ban. Okay, so the issue we're talking about this evening is the updates on Sullivan v. Ferguson, which, as we recall, is the lawsuit here in the Western District of Washington to overturn 9.41.375. Now, here's the exciting news, is that this case is going to proceed on the merits. What do I mean by that? Well, you see, when you have multiple plaintiffs, like you do in this case, who then sue multiple defendants, so there are many, many named defendants in this suit. There's the Attorney General, of course, and then there is the King County Prosecutor, the King County Sheriff, the Kitsap County Prosecutor, the Kitsap County Sheriff, because two of the named plaintiffs, that being Rainier Arms and Sullivan, are residents or businesses either in King County or Kitsap County. Therefore, if they were to try to break this law, those laws would be enforced by those government entities. And so the lawsuits are against many different government entities and individuals acting in their official capacity. Now, when this happens, okay, when you have plaintiffs suing a whole bunch of defendants, all the defendants get together and they file what's called 12B motions, 12C motions, Rule 51 motions. What are these, okay? Well, these are rules that say, hey, listen, you know what? The plaintiffs over there, they haven't even stated a cause of action. You know, even if you take all of their pleadings and you read them at face value, give them in the light most favorable to them, they have not even stated a claim here under which they can proceed to trial on, okay? That's one of the things. The other thing is that you can have things known as summary judgment. Now, again, I'm not a civil attorney, and we're not going to get too deep into that. That's pretty real geeky, high-level stuff here. But on a surface level here, what a Rule 51 motion is, hey, you know what? Even if we take all of the pleadings and take a look at what our position is on it, is since there's no material disputed facts, we can determine that there's no legal ground for them to stand on, and so the suit should be dismissed. So what you have early on in a lawsuit is a lot of motions to dismiss the lawsuit or to eject a particular defendant from the suit. So if the King County Prosecutor's Office prevailed, then no longer would Dan Satterberg, the elected King County Prosecutor, or the King County Sheriff be named as a defendant. Okay, same thing with Kitsap County. They attempted to do the same thing. However, and this is the good news, despite everyone's attempt to say, hey, the plaintiffs don't have a cause of action, the plaintiffs' pleadings are insufficient, even if you accept the plaintiffs' pleadings for everything that they say, that there's a summary judgment motion, we win on the merits anyways, essentially the scoff motions. This is when the other side just scoffs at what it is you're filing. And don't kid yourself. These motions are granted often, not only because when you're trying to encapsulate a large group of defendants, occasionally you do have problems proving standing or subject matter jurisdiction as it relates to those people. This is everyone's escape hatch. Now, they do this for multiple reasons, but one of the big reasons they do this is because they don't want the case to be heard on the merits. See, if you're a named defendant here and you're sitting there looking at the state of the current law, and perhaps you've read the Bruin opinion, you might be a little skeptical about your chances of surviving. So what's the only way to prevail on this lawsuit? Well, it's to get some judge to throw the lawsuit out. Well, the Honorable David Estudillo of the Western District of the state of Washington in the United States District Court was not persuaded by any of the arguments made by either King County or Kitsap County. Now, I got to tell you that I've had a chance to read the court's order, and we're going to share some of the quotes from it. But there were some really disingenuous arguments here. But here's what it also tells me, is it kind of reeks of desperation here, because some of the claims that King County and Kitsap County was making as to why this lawsuit had no merit whatsoever, or why they could not be drugged into this lawsuit, really reeks of desperation. I think you think the same once you've had a chance to see what they were actually claiming. Now, just to give you an idea of exactly what this ruling is about, the judge's concise statement of this ruling is as follows. This matter comes before the court on multiple defendants' motions to dismiss for lack of subject matter jurisdiction and for failure to state a claim upon which a relief can be granted. For the reasons articulated herein, the court denies in part the defendant's motion to dismiss for lack of subject matter jurisdiction and for failure to state a claim upon which relief can be granted, and grants dismissal as to plaintiff's claims brought pursuant to 42 U.S.C. Section 1983. Now, in a nutshell, what the court is saying here is, hey, listen, all of the claims by King County and Kitsap County that they didn't state a claim, that they don't have subject matter jurisdiction, no. They do have a claim. They do have subject matter jurisdiction. This is a just lawsuit. Now, there was an additional suit filed under Section 1983, which in a nutshell is a violation of constitutional rights while under the color of state law. And when you geek out and you read the pleadings, you realize that the plaintiffs' pleadings in that area were a little inadequate. And I think the reason was, and I'm not knocking plaintiffs' counsel because they're doing a really good job here, I think that they really put all their eggs in the other two baskets, which was a very wise legal move. Now, both King County and Kitsap County tried to say, hey, listen, there's not even a subject matter jurisdiction. The court doesn't even have jurisdiction to hear this because they haven't even stated a claim. Now, the court was not persuaded by that argument and was really less than impressed with the defendant's briefing on this issue. The court stated, a motion to dismiss for lack of subject matter jurisdiction can either attack the sufficiency of the pleadings on their face or may present affidavits or other evidence that contest the truth of the allegations in the pleadings. Where the moving party does not present affidavits or other evidence challenging a plaintiff's factual allegations, the court must accept all factual allegations in the complaint as true and must construe the pleadings in the non-moving party's favor. Both the Kitsap and King County defendants assert that this court lacks subject matter jurisdiction to hear plaintiffs' claims. Neither the Kitsap nor King County defendants appear to offer evidence in the form of affidavits or otherwise challenging the allegations in the complaint, and so the court construes their motion as facial attacks on this court's jurisdiction. The court thus presumes the allegations in the plaintiff's complaint to be true and draws reasonable inferences in their favor. So, the court's saying, hey, listen, you're saying that we don't have subject matter jurisdiction, and then you're offering no evidence in support of that, and therefore we're going to accept what the plaintiffs are saying as the gospel in this matter. Now, the King County defendant is Rainier Arms. They're located in Auburn, and this is one of the other very disingenuous arguments that the King County prosecutor's office made here, which was, hey, listen, you know what? We're the wrong party because if Rainier Arms sells high-capacity magazines, it's a gross misdemeanor, and so therefore it would be prosecuted by the Auburn Municipal Prosecutor's Office, the prosecuting attorney that handles misdemeanor and gross misdemeanor offenses inside the city of Auburn. Of course, they forgot the fact that the law would permit concurrent jurisdiction, which would allow the King County Prosecutor's Office District Court Division to also prosecute any misdemeanor or gross misdemeanor that occurs anywhere inside of King County, whether it's inside or outside a city limit. The court specifically stated, King County defendants, plaintiff Rainier Arms has sufficiently alleged that it has standing against each of the King County defendants. First, Rainier Arms has sufficiently alleged that it suffered an injury in fact. Economic injury caused by a prospective statute is sufficient for standing to challenge the statute. The King County defendants assert that Rainier Arms failed to articulate a concrete plan to violate law, which they view as fatal to any pre-enforcement challenge to the act. But Rainier Arms' ongoing economic injury is sufficient to establish that they have suffered an injury in fact. And again, the prosecutor kept coming back and saying, well, yeah, I know that we have the ability to prosecute Rainier Arms, but, in practicality, it's highly unlikely that we would ever do that. The court was not persuaded by that disingenuous argument either when they ruled. The King County defendants do not rebut that these officials have the actual power to prosecute Rainier Arms, but instead argue that there is no genuine realistic threat that the King County authorities would investigate or prosecute Rainier Arms for a misdemeanor committed within the city of Auburn. However, Washington Revised Code 3934-180 does not grant exclusive enforcement authority of misdemeanor offenses to the City of Auburn. It merely addresses the responsibility for and apportionment of the cost and expenses of the administration of justice at the local level. And then, of course, Kitsap County tried the same move with Miss Sullivan, the named plaintiff there, saying, hey, listen, she cannot establish subject matter jurisdiction or standing to even make this challenge. The court was not persuaded there either when they ruled as follows. Miss Sullivan, a resident of Kitsap County, alleges that it is her present intention and desire to purchase large-capacity magazines, but she's unable to do so because the existence of the act and defendant's enforcement of it has extinguished the legal market for those items in Washington and made it unlawful for Miss Sullivan to import them herself. These allegations sufficiently establish that Miss Sullivan has standing as against the Kitsap County defendants. So ultimately, the court came to the final three rulings as it related to these preliminary motions to dismiss or to eject particular defendants from the suit. The court's rulings were as follows. The King and Kitsap County defendants' motions to dismiss for lack of subject matter jurisdiction pursuant to Federal Rules of Civil Procedure 12b-1 and 12c are denied. Additionally, the court denies the King and Kitsap County defendants' motion to dismiss for failure to state a claim upon which relief can be granted insofar as they apply to plaintiffs' ex parte Young claims for declaratory and injunctive relief. 3. The court grants the King and Kitsap County defendants' motion to dismiss plaintiffs' claims based on 42 U.S.C. Section 1983 for failure to sufficiently plead a Monell claim. So just to recap, yes, the Section 1983 deprivation of civil rights under the color of state law was dismissed. However, and this is really important, and this is the big, huge victory, the jaws and the teeth of this lawsuit, it continues on, and it continues on against every one of the named defendants. Despite both King County and Kitsap County's very disingenuous and tenacious efforts to get out of this lawsuit, this court, this judge, was very wise judge, was not persuaded by these arguments. What this means is the part of the lawsuit that could get a temporary injunctive relief, the part of the lawsuit that could get a permanent injunction, and the part of this lawsuit that could ultimately strike down 941-375 as unconstitutional, that continues full steam ahead. Listen, in the meantime, if you have any questions about this or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.